I'm Drew Stevenson, and this is a video from my Law and Economics seminar about the concept of the best cost avoider, sometimes called least cost or cheapest cost avoider, a very useful concept that can be applied in a number of areas of law using insights from economics. So let's talk about the best cost avoider concept. The best cost avoider or least cost avoider refers to the individual or entity who is in the best position to prevent or mitigate the harm caused by a particular legal action or event that has legal significance, like a tort or harm or breach of contract or a crime or something like that. Who, in other words, if we're talking about a harm or an injury, whether it's economic or property damage or something like that, who can avoid that the most easily or with the least cost, sort of upfront, looking at it ex ante. And so the concept is based on principles of efficiency and social welfare. The idea that resources should be allocated in a way that minimizes maximizes the benefit to society. And so we're going to talk about allocation of resources, efficient or optimal allocation of resources in another video. And there's a sense in which this concept of best cost avoider overlaps with that. And so in the context of tort law, for example, the best cost avoider is typically the individual or entity who is best able to prevent or reduce the harm caused by their actions, that is, for the lowest cost. And here's some examples. In a personal injury case, the defendant may be considered the best cost avoider if they're able to take steps to prevent similar accidents from happening in the future. So sometimes the tortfeasor or the person who is negligent, it would have been easier and cheaper and requires less investment and attention and time and so forth, resources, for them to take some basic precautions than for everyone else, every potential victim, to have to be more careful. And so in this way, the concept of best cost avoider can be used to determine which party is ultimately responsible for compensating the victim for their injuries. And that's very important. We're going to come back to that in a moment. And so again, if we're asking who is in the best position to prevent this, are we talking about maybe the manufacturer of a faulty product? So if you think about it, ultimately a tort law product liability case is making a decision about whether the consumer should bear the risk of being injured from a product or if the manufacturer should bear that risk. Well, in some cases, we think the consumers are basically it's buyer beware, right? Then they should use their caution or get their information or examine a product before they buy it. But sometimes there's items that, for example, a computer or a phone, where it's very hard for a consumer when they're buying something to know what's inside that product and if it's all manufactured properly and so forth. And the manufacturer is in the much better position to know that. So the manufacturer of a faulty product is usually in the best position. And so the idea of best cost avoider underlies a lot of our product liability. Let's talk about property owners, right? So if the property owner knows what injuries are at risk, right? They know that they have a slippery sidewalk, or a slippery entryway, or that there's a tear in the carpet that people trip on all the time, or that the elevator always gets stuck, or that people keep getting shocked when they plug things into the wall outlets, and so forth. And so you probably read some of these cases in your torts class about property owner liability. And if they didn't mention it expressly, it at least is kind of an assumed idea in the background that, for example, with hotels, right, that the person who stays at the hotel doesn't, you're a guest, right? So you don't have any way of knowing what the most dangerous spot and the spot where most of the accidents that happen in the hotel occur, but the hotel owner does, right? Because they're there all the time and they can keep track of the accidents and injuries that occur, or the crimes that happen, the assaults that occur at the hotel, or whatever it is. And so the property owner has the best information and might be in the best position to take remedial measures to prevent the harm from occurring. On the other hand, sometimes the injured parties are taking risks, and so they know this, right? And that's the idea of contributory negligence. And this, in a sense, contributory and comparative negligence is the idea of really comparing who is the best cost avoider in that situation. And so if you were driving recklessly and you knew you were driving recklessly, or you knew that you were on medication that made you impaired, or that you couldn't see, or that you were high risk for having seizures while you were driving. Well, other drivers on the road don't know that. They don't know that the driver in this car has a seizure disorder, let's say. And so sometimes the victim of the accident was aware that they were at special risk and should have taken extra precautions, and the tortfeasor had no way of knowing that they were. And so ultimately we're looking for some sort of objective criteria for who should be responsible for bearing the costs associated with an accident or injury after the fact. And then if we're going to hold them liable for an injury that's already occurred, we're also essentially assigning them the responsibility to take precautions in the future. So the best concept of best cost avoider is closely related to the principle of strict liability, which holds that an individual or entity can be held responsible for damages even if they were not negligent or at fault. You must have done at least a unit in one of your semesters of torts in your first year of law school about strict liability. And so a lot of case books or law school courses will give you a case about building demolition companies, right? These companies that use explosives to demolish a building because we want to build something else on the site. And I was taught in my torts class that we have strict liability for inherently dangerous activities, right? And that's a phrase that the courts use a lot, right? So blowing up buildings, using explosives is inherently dangerous, obviously. And so therefore it kind of makes it sound like a moral judgment, like you're doing something that's inherently dangerous, so we're just going to always make you pay when somebody gets hurt. But there's also a logic to strict liability, let's say for building demolition, that really makes a lot more sense based on the best cost avoider idea. So, and I want my students to think about this. For the bar exam or for your first year torts exam, connecting strict liability with inherently dangerous activities was the correct answer for the test. But it doesn't make that much sense in practice. If you think about it, every personal injury case involves an inherently dangerous activity, right? Somebody got hurt. So driving your car is an inherently dangerous activity. Flying in an airplane is inherently dangerous. And shaving in the morning is an inherently dangerous activity. So a lot of things we do are inherently dangerous. And so the idea with building demolition in the case books, kind of first year torts, is, I know, but explosives are just really, really inherently dangerous, extremely inherently dangerous or something. But it's not always clear, right? You could have it be done very safely. And so if we think about it in terms of the best cost avoider, the demolition company is by far the best position to develop the safest possible methods, right? So these bystanders, that you're walking by a building and it's being demolished that day, and if the demolition company has no incentives to take precautions, then we could have debris and broken glass and things like that shoot for a mile, right? And kill innocent bystanders who had no idea that there was going to be an explosion that day. So the demolition company has the incentive, because we assign strict liability to them, to develop ways to have things implode, the building to mostly fall in on itself. So you can have things like in the picture here, where you can have people kind of close enough to take pictures and listen to the sound of the building come down and so forth, because this is now done so safely. And why? Because the demolition company was in a much better position than all those people to figure out how to have this happen in a safe way, and to have the people not get injured. Also, the demolition company knows the day and time and range of damage in advance. They can announce it. They can cordon off the sidewalk and kind of create a buffer zone. They can put the community on notice. And so if you're walking down the street, you may have no idea like what time the building is going to blow up, but the demolition company does. And so they can pick a time that's where maybe there's the least number of crowds around and so forth, or the fewest number of children that could be injured and so forth. So again, there's really an argument that maybe we should hold them strictly liable because they're by far the best cost avoider, not just because the activity is inherently dangerous, because a lot of the activities we do are inherently dangerous. Also, the principle is often applied in, as I said, in cases involving product liability, where the manufacturer of a faulty product is held responsible for any injuries or damages caused by that product. So this concept of best cost avoider that comes up a lot in product liability cases. In addition to its application in tort law, the concept of best cost avoider can also be used in other areas of law and economics, like contract law and environmental regulation. So let's have some examples. For example, in a contract dispute, the best cost avoider may be the party who's best able to prevent or mitigate the harm caused by a breach of conduct. So if you think about it, you have two parties to the contract. And then when there's a breach, one of the parties might suffer a devastating loss if they had all their investment up front, whereas the other party would be able to absorb the loss from the contract going south or a breach of contract and so forth. So sometimes we may assign responsibility based on who's the best party to absorb the cost or to prevent or mitigate the harm caused by a breach of contract. This comes up also in environmental regulation. The best cost avoider may be the party who's best able to prevent or reduce the negative impact of economic activity on the environment. So obviously you might say, well, why don't we just hold the polluter responsible? But sometimes it could be the landowner who's allowing the polluter to dump on their property, or the transporter, or things like that. So sometimes we can pick apart a situation where, let's say, pollution is being put into the air or dumped into the water, and look at each kind of step in the chain, and then figure out who in that process, whether it's the person who manufactured the toxin, the person who decided to dispose of that toxic substance in the open environment to pollute, the person who drives the truck to the site and dumps it, or the property owner who invites them to do that, or the person who buys the land from that property owner knowing that it's already polluted. And so we have this discussion in environmental law sometimes of trying to assign cleanup costs to the best cost avoider in the process ex ante. Now, why is this so popular with law and economics? Well, it gives us an objective criteria versus kind of sort of emotional or sentimental notions of who deserves what. So in a lot of torts cases, you have things where somebody feels we talk in very moral terms, like, oh, you should have been more careful, or the reasonable person standard, right? A reasonable person would have been taking more precautions, or that victim should have been more careful, or things like that. And a lot of this was really an expression of a value judgment and blameworthiness, and sounds very moralistic and judgmental. And the best cost avoider is basically a calculation, right? So it gives us a nice objective criteria for assigning liability instead of something that's to some extent based on feelings and values that people have, that sometimes people have trouble articulating. So in most cases, the party who is best able to control or prevent the occurrence of a particular negative event should be responsible for bearing the costs associated with that event. Okay, so where does this leave us? Well, when we ensure that the costs of legal problems are borne by those who are best able, or for the least cost, to prevent or minimize those costs, it helps align incentives properly and encourages the adoption of practices and policies that prevent the harm and reduce the legal costs. And that concludes our lecture about best cost avoider.